Counsel for the Applicants, old students of the Selikem Senior High School. With me is Konadu, second counsel for the applicants. In my 14 minutes here, I'll be speaking on the first and second issues presented before this honorable court, which are whether the failure to admit Kofi Painstow was in breach of his human rights, and whether the ban on religion was in breach of the rights of the students. My co-counsel will be speaking on with the remaining 6 minutes on the last issue, which is whether the different classifications of attires to be worn by students for discrimination. We reserve 2 minutes for rebuttals. Your Lordships, regarding the first issue, which is whether the failure to admit Kofi Painstow was in breach of his human rights. It is our submission that the failure was in breach of his rights, first, to education, guaranteed under Article 25 and Article 28 of the Constitution. Second, that the failure to admit Kofi Painstow was in breach of his rights to religion, guaranteed under Article 21C and Article 26 of the Constitution. We would also be relying on the case of Tyrone Magai versus Achimota School and the Attorney General. Your Lordships, at this point, I will begin my first sub-argument under the first issue, which is on the basis of education. In this sub-argument, we submit that the failure to admit Kofi Painstow into Selikem Senior High School would breach his rights to education guaranteed under Article 25 and Article 28 of the Constitution. Article 25 of the Constitution says, permit me to read from the Constitution, that every person shall be entitled to equal educational opportunities. Your Lordships, Article 28 of the Constitution also says that no child shall be denied of their rights to education simply because of religious or other beliefs. Your Lordships, applying the law to the instant case, it is our submission.
Counsel, sorry. You made mention of Article 28. You speak of Parliament shall enact a law. Has Parliament enacted a law? And which part of that law are you focusing on? Article 28.
Yes.
It starts off by saying Parliament shall enact laws that are necessary to ensure that, and goes on. So my question to you is, has Parliament passed that law? And if so, which section of that law are you basing your argument?
Thank you very much for the question, Your Lordship.
You may proceed.
Thank you. In these provisions, we are made aware that education must be accessible and must be on the basis of merit. Your Lordships, relating the rules to the facts of the case, it is our contention that the failure to admit Kofi Painstow into Selikem Senior High School was in breach of his human rights because he was denied access to this school even after he had merited admission into the school. Your Lordships, may I invite you to turn with me to paragraph 2 of the facts of the case. Your Lordships, in this paragraph, we are made aware that Kofi Painstow did pass his BECE, and further down in paragraph 4 of the facts of the case, we realize that he was indeed placed into Selikem Senior High School by the CSSPS. The CSSPS is a computerized, merit-based classification system. Your Lordships, further down in paragraph 5, we are made aware that he did have the items required for him to be placed as a resident student. However, Your Lordships, in paragraph 9 of the facts of the case, we realize that he was denied access into Opimpim Senior High School simply because he wore his hair in dreadlocks. Your Lordships, it is our submission that because he was denied access to the school, even after having the requirements, which are to pass his BECE, to be placed into the Opimpim Senior High School by the CSSPS, and to have the required items to be a resident student, he was still denied access into the school, simply because he wore his hair in dreadlocks. And for this reason, we believe that his right to education was breached. Your Lordships,
Before you proceed again, let me ask you this question. Gaining the admission, must an individual not well comply with the rules and regulations of the school? I think that is how you gain the admission. You pass all your stuff, you pass the exam, you pass your marks, but there are rules and regulations in the school which you need to comply with. So if you are not willing to comply with the rules and regulations, how can you make the agreement that you will be denied access to the school?
Your Lordships, thank you very much for the question. In answering this question, I say that yes, there are rules and regulations in the school. However, constitutional rights cannot be waived. In that, so long as it is a constitutional right, this right cannot be denied of him, even if he unknowingly waived his rights in a way. Your Lordships, secondly, in response to this question, it is true that there are school rules in every institution, and it is true that schools are mandated to have these schools for easy management of the students. However, Your Lordships, in Article 1, Clause 2 of the Constitution, it is expressly stated that the Constitution shall be the supreme law of the land, and any other law found to be inconsistent with the Constitution shall be to the extent of the inconsistency void. Your Lordships, it is our contention that the rule in this school, if enforced, could lead to the breach of the human right of the right to education of Kofi Pencil. For this reason, it is inconsistent with the Constitution. And for this reason, this particular rule must be considered null and void. Your Lordships, if I may proceed with my
Counsel, are you saying that in all human rights are absolute?
No, respectfully no.
Who explain this?
Human rights are not absolute. However, human rights are subject to limitation per the Constitution in Article 12, Clause 2, to public interest and to the breach of the rights of other people. Your Lordships, we submit that no way is Kofi Pencil's hair in manifestation of his right to religion will the public be disadvantaged, because nowhere is it stated in the facts of the case that Kofi Pencil's hair was kept in a manner that would disrupt the teaching and learning environment in the school. May I proceed? Thank you very much. Your Lordships, having concluded my first sub-argument under his rights to education, I will now move on to the second sub-argument under his rights to religion. Your Lordships, it is our contention that Kofi Pencil's rights to religion was breached in this instance case because his right to religion guaranteed under Article 21C and Article 26, because the school was not willing to permit him to keep his hair in school, which was a manifestation of his religion. Your Lordships, we would be relying on Article 21C and Article 26 of the Constitution. We would also be relying on the case of Tyrone Magai versus Achimota School, suit number HR 005-2021. Your Lordships, in this case, it was determined that a student who claims he maintained his hair in manifest of his religious expression should be allowed to do so, so long as there is no compelling disadvantage to the student's community. Your Lordships, applying this rule to the facts of the case, it is our contention that Kofi Penso's rights was breached because his hair in manifest of his religion was in no way disadvantaging the student's community, and so it was not subject to constitutional limitation. So this limitation would breach his rights to religion, to religious expression, guaranteed under Article 21 and Article 26 of the Constitution.
Council opinion is a Tyrone Magai decision binding on this court?
Respectfully, Your Lordships, we do admit that it is not binding in this court. However, we pray this honorable court to allow us to use this case for persuasive effects. Secondly, on this question, Your Lordships, the Tyrone Magai case, this instance case, falls on all fours of the Tyrone Magai case. And so, the issues that were decided in that case may be applied in this court.
Proceed.
Thank you. Your Lordships, applying the law to this instance case, we view permit me, I invite you to turn to paragraph 9 of the Constitution, of paragraph 9 of the facts of the case. Your Lordships, in this paragraph, it is clear that the purpose of his hair is a manifest of his religion. It is also clear that having expressed that, the school still denied him access to be admitted. Your Lordships, for this reason, we contend that his rights to religion was breached.
If you look at paragraph 11, the school gives you a justification why we believe that there ought to be something. The school's justification for saying was that the proliferation of different religions meant it was not sustainable for the school to provide adequate facilities for all to present their religious freedoms effectively. So it's not about him by other religions. So that's the justification. Is that justification rational in your opinion?
Respectfully, no. That justification is not rational. Because, Your Lordships, it is our submission that constitutional rights, it is our submission that these are constitutional rights. And inasmuch as the school may not be able to have the facilities to adequately engage these activities, the school should not impede the rights of others to do so, simply because it will be convenient for them and it would help them manage the school. They are supposed to figure out a way to manage the institution in line with the Constitution. Your Lordships, it is our submission, therefore, that students should not be It is our submission that students should not be allowed to waiver their rights simply because of the inadequacies of the school in this regard. Your Lordships, having concluded my first issue and my second issue, I will now seek for my co-counsel.
Before you do this,
educational writers, she's doing rights. You do that. So, with socioeconomic rights, we are progressively realized. Are you aware of that? Before I continue. So then if you are supposed to realize the progress in there, what would you suggest? See, you say you mustn't wait here, like, I agree. But what suggestion would you make as to what the school can do whilst not waiving the right, also so that public, the good of the public also is not compromised? Do you understand my question?
you basically understand that you enjoy your rights subject to respect for others' rights, so that if we're all allowed to manifest I would walk in here, instead of some oil, where's the junction?
Your Lordships, respectfully, it is our submission that such instances are excesses, and such excesses rarely happen. However, Your Lordships, even with regards to the facts of this case, there is no statement that there is such an excess. However, Your Lordships, if there is to be such an excess, these excesses are restrained by the Constitution. Your Lordships, the Constitution in Article 12, Clause 2, states that everybody's right to fundamental human rights can be waived based on public interest and the rights of other people. To Your Lordships, if such excesses do fall under the ambit of Article 12, Clause 2, then they can be constitutionally limited. However, Your Lordships, such excesses are not in the instant case. However, therefore, we believe that with the facts of the case, the rights of these students cannot be limited.
Thank you.
Respectfully, sir.
Mr. Kwasi, Etsiakoh Konadu. Let's hear it.
Respect to Your Lordships. Kwasi speaking as the co-counsel for the applicants. Within the 6 minutes I have been given, I will be addressing the issue as to whether the classification of clothing to be worn by second and third year female students of a mandatory is discriminatory. Your Lordships, we contend that this classification is discriminatory because it contravenes Article 17, 1 and 2 of the Constitution. Respect to Your Lordships, if you tell me to the others. Article 17, 1 and 2 states that all persons shall be equal before the law, and a person shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or social or economic status. Your Lordships, we will be relying on the case laws TT Nati vs. Gatti, suit number J6 12010, July 2010. Your Lordship, per the pronouncement of the courts in TT Nati vs. Gatti, unlawful discrimination occurs when there is no justification for the differentiation in the treatment of persons who are similarly placed. Your Lordships, we will also be relying on the case law Shrash and Shrash Grace Ofusu and Mahamud versus the Ghana National Fire Service, suit number HR 0063 2017. Your Lordships, in this particular case law, 3 criteria were established for determining wrongful discrimination. Your Lordships, the first criterion was the party must be protected under the relevant law of discrimination. The second criterion was the party must have been subjected to adverse treatment. And the third criterion was the grounds stated in Article 17 must be factors for the adverse treatment. Your Lordships, consequently, we will be using these as our arguments. The second and third year female students of Opimpim Senior High School are protected under Article 17 clause 1 of the Constitution, which states that all persons shall be equal before the law. And the second clause, which states that no one should be discriminated against on grounds of things like gender.
Mr. Green, sorry.
Pardon me, Your Lordship.
But I thought Natia Ngati tells us that in reality, all persons are not equal. And my Lord Justice, that one specifically stated that there are some class of professions or professionals in this country who, when you compare to others, are not equal. You specifically mentioned policemen, judges, and other people who enjoy certain benefits as compared to an ordinary Ghanaian. So that how do you reconcile that point that we are actually not equal when Article 17.1?
Thank you very much for the question, Your Lordships. Your Lordships, T.T. Nate versus Gatti tells us that unlawful discrimination occurs when there is no justification whatsoever for the difference in treatment. However, people may be treated differently if there is a reasonable justification, such as on the basis of their career. Your Lordships, permit me to move on. So, per the second argument, the second and third year female students of Opimpim Senior High School have been subjected to adverse treatment. Your Lordships, why do we say so? We say so because their right to expression, guaranteed under Article 21 of the Constitution, has been breached. This prevents them from being able to express their identity as students. Your Lordships, second, they are being required to wear a particular attire, which means they cannot wear anything they want to wear, and as such, they have an extra burden of cost to acquire these items, even if they are not economically able. Your Lordships, third, they have the problem of stigma, because we can all attest to the fact, Your Lordship, that senior high school students are a bit petty psychologically, and as a result, being required to wear certain clothes will make them feel segregated from the rest of the population.
Mr. President, it's wearing of uniform not part of discipline and orderliness in school.
Your Lordships, let's kindly come with me to paragraph 1 of the case. Paragraph 1 of the case. Paragraph 1 of the case tells us that Opimpim Senior High School has discipline as a hallmark. Even though the paragraph says that, when you move to paragraph 12, there is no indication that discipline is the reason for this difference in attires. Your Lordship, therefore, it will be a bit unfounded to infer this together. Besides that, Your Lordship, all other students are required to wear whatever they want to wear. As such, it defeats the purpose of discipline. Permit me to move on, Your Lordship.
Proceed.
Your Lordship, the third criterion requires that the factors for the adverse treatment should be aligned in Article 17. And this is what we see, as these students are being discriminated against on the basis of gender. This is because second and third year male students are not required to dress a particular way. Second, first year female students are not required to dress that way, and therefore they are also being discriminated against on the basis of their class. As such, this meets the requirement of the third criterion. The factors for discrimination are stated in Article 17. The question to ask now, Your Lordship.
I ask you questions, so you will give an answer one.
The question to ask now, Your Lordship, is whether the adverse treatment is justified, legitimate, or proportional. Your Lordship, there is no justification given in the statement of facts for this. There is no legitimate reason given in the statement of fact for this. And it's not proportional as second and third year female students are required to wear a particular attire, or second and third year female students are left alone. Your Lordships, this means the requirement set for discrimination in active verticality has been achieved, and we contend that this is discriminatory. Your Lordships, we pray the courts to adjudge and declare that 1. The refusal to admit Kofi on the basis of his dreadlocks is discriminatory and then breaches his educational and religious rights. That 2. The ban on all religions is an affront to the rights, the religious rights of the students. And that 3. The classification of clothes mandated to be worn by second and third year female students of Pretoria Senior High School is discriminatory against them. Respectfully submitted, the applicants.
Good morning, Your Lordships. I'm Tehilla Ogochuku-Nweke, here with my co-counsel, Ms. Golda, Selikem, Amegashie, and we are counsels for the respondent in the matter before your honorable court. I shall be addressing the first and second issue. Tehilla Ogochuku-Nweke. I shall be addressing the first and second issues within a stipulated time of 12 minutes, and my co-counsel the third issue in 8 minutes. If the court permits, I shall proceed to my substantive argument. The first issue for consideration by the court is whether or not the failure of the school to admit Kofi Painto was in breach of his human rights. The position of the respondent is that not admitting Kofi Painto because of his hairstyle is not against his human rights, as this is part of the school regulation for effective management. There's no denying the fact that the Constitution entitles all to enjoy their fundamental human rights as stated in Article 12 Clause 2 of the Constitution, which, with your permission, every person in Asawa shall be entitled to the fundamental human rights and freedoms of the individual contained in Chapter 5, but subject to respect for the rights and freedoms of others and for public interest. It's important to clarify, Your Lordships, that the benefits accrue only when there's respect for the rights of all others and for public interest. And this is what we believe is the bedrock of our argument. Respondents are of the opinion that the desire of Kofi Painto to fully benefit from Article 12 Clause 2 is once again dependent on the respect of others and for public interest. Public interest, as stated in Article 295 of the Constitution, with your permission, includes any right or advantage which inures or is intended to inure to the benefit generally of the whole people of Asawa. This makes us understand that whatever decision is taken must be taken for the entire benefit of all the people of Asawa. For Asawa, the public interest with regards to education is ensuring that their children are brought up in an environment characterized by orderliness and fairness. To permit Kofi Painto's dreadlocks represents unfairness and injustice for the rest of the students who may have some good reasons to appear in ways not prescribed by the school.
No, you see, yes, your last statement in regards to your submission, in my view, makes it speculate. Then, apart from the fact before this course, where it is clearly stated that other students believe that by giving confidential admission, he elevated his right above theirs.
My Lord, respectfully, the facts of the case according to... No, there isn't.
Yes.
But respectfully, the facts of the case according to paragraph 1 states that, if you would permit me,
yes,
that Opimpim Senior High School has been adjudged the best senior high school by West Africa. The main hallmark of the school is discipline, implying that its successes has been as a result of discipline.
but what is a rational connection? What is a rational connection between wearing the dreadlocks and this?
Yes, my Lord. In achieving discipline, the environment has to promote or has to be fair and has to be uniform for everyone. Once this is not fair, it's going to actually affect the educational attainment of other people. In the sense that Kofi's constant presence in the school undermines the rules of the school that have enabled it to promote discipline and be the best school in Asawa in the past 15 years. Allowing him is going to send a message across to all that preference can be given to certain people. This will indirectly affect the environment in which they study, as it will now be characterized by unfairness. This may distract the students from their academic focus and deprive them from benefiting from the good name of Opimpim Senior High School. My lords, Article 23 enjoins administrative bodies to act fairly and reasonably and in compliance with the law. When it comes to the fairness and reason backing Kofi Paintel's denial, we come from the principle of whether it is necessary and whether it is proportional for the school to set up the rule or to deny Kofi Paintel entrance because of his dreadlocks. For necessity, the facts of the matter once again establish that Opimpim's 15-year dominance has been as a result of its adherence to discipline, hence the rules it has put in place in order to ensure this discipline. In ensuring discipline, it sets out rules of conformity and fairness in order to create a sense of orderliness to facilitate the continued focus of the students on their academic goal. Hence, it is necessary. The paragraphs. Yes, my lady. Yes, my lady. In the first paragraph of the facts of the case, we are basing our arguments on the fact that Opimpim has come this far because of its adherence to discipline.
Any other paragraph?
For necessity, no, my lady. For proportionality, proportionality implies that the disadvantages of the ruling do not outweigh the advantages. Permit me, your lordships, to state the advantages and disadvantages of this rule or this denial of Kofi Paintel. For the disadvantages, he will not be able to fully realize his religion as stated in Article 21, Clause 1c. However, this flaw is limited because it does not take away his religion from him. He's only being prevented to fully realize his religious rights within the confines of the school. Hence, he's not subject to do away with his religion entirely.
How would you respond to somebody who make the argument that asking him to carry his bread would be akin to asking him to be scared to lead his own life? What would be your response to it?
My lord, respectfully, that is why the school, as will be addressed in issue 2, banned religious activities altogether.
Banning everybody, but don't you realize that you're basically infringing on the rights of these students to manifest their religion? The Constitution clearly says that everyone has the right to manifest their religion.
My lord, that right is limited by the latter part of Article 12, Clause 2. It has to be fair to every other person and it has to uphold public interest. For the advantages, it ensures that all are treated fairly and no one is disadvantaged, hence conforming to Article 12, Clause 2 in respect to the rights of others. Also, this rule has been put in place in the past 15 years and has in no way affected the attainment of education of anybody in Opimpim Senior High School as stated in the facts of the case. Hence, it takes nothing away from the students. This is an advantage that outweighs the disadvantages. Hence, this rule is proportional. Your lordships, in emphasis of the statements made by Justice of the Supreme Court Dateba in the TT Nati versus Godwin Gatti case, he clearly pontificated that equals must be treated equally. Kofi Paintel, in the opinion of the respondents, we see him as being unreasonable in his demands as he seeks to be a step above his colleagues who have already conformed to these rules. My lords, we therefore plead with this honorable court to declare and affirm the school's denial of admission to Kofi Pento, that it was lawful and the school has the authority to enforce rules of equality for all so as not to compromise the stance of discipline in the school. In the absence of any questions, may I be permitted to move on to issue 2?
I get to equity. Do I get to equity particular hairstyle to this?
My lord, the school has set out rules to ensure uniformity, to ensure that discipline is adhered to. And in doing so, it sets a uniform haircut as part of the uniform in order to create an environment of orderliness and fairness. Hence, he coming in with his haircut, knowing very well the rules of the school, because even his father was a past student and is currently the president of the Old Students Association, so he very well knows the rules. He coming in is trying to be above other people who have had to conform to these rules. And this, kindly, your lord, my lord, is not discipline being adhered to.
So clearly, from the matter before us, arguments, given the question, this is the first time the applicants as regards the student and school, etc.
Due to the fact of the
with regards to submissions of equal treated alike, how will this argument sit with you guys? Since it's the first, let's start treating those within that class. If subsequently there are last time we treat them like was certainly like me, that we also treated like. Students, all students are treated like this. Let's say let all Muslims be treated like. Let all Muslims be treated like. I would like to say.
Respectfully, my lord, this takes us to the second issue as to how well the school can ensure, or how well the school can fully guarantee the religious right, or the full realization of the religious rights of other people. If I'm not mistaken, you are attributing this treatment with respect to religion. So kindly, may I move on to issue 2?
Or we can say minority rights.
For now, he's able to use it.
Yes, minority rights.
I think she's good.
It's going to be, you understand that? I'm just affirming what my law says. I'm just recontextualizing and saying that how minority rights be treated. Because for now, it's a rule very much in the minority. Do you understand? It's the same as a group of Muslims against people, the wider Christian community, a group of Hindus against the wider Muslim. So this is the Rastafarian against the bigger Christian or Achimota School, whatever community.
How are the interests and rights to keep them? We all know
Your
the
Lordship.
using that under the carpet, just because the majority is listening.
Your Lordship, from the facts of the case, we can imply that this is the first encounter with minority and the school. We can also state that there are other religions in the school who have had to conform to the rules of the school. So kindly to the applicants, what exactly is stopping Kofi Pento from conforming to the rules of the school? Because others have done it. There are Muslims in the school, there are maybe Hindus in the school, and they have had to conform to the rules of the school.
Is right. You understand? Others doing conforming doesn't mean the status quo cannot be challenged. This is what young
Respectfully, my lady, as stated in Article 12, Clause 2, his rights and freedoms are limited if what he is seeking does not uphold public interest and respect for others, which I expounded upon earlier, Your Lordships. The second issue, or the question whether the ban on religious activities by the school was in breach of the human rights of the students, shall also be answered in the negative as respondents. This is because, most grateful, Your Lordships. This is because the proliferation of religious rights, in the opinion of the respondents, will bring chaos and also stretch the facilities of the school, making the school difficult to control. In addressing this statement, I would also like to answer this question based on whether it is necessary and whether it is proportional. Your Lordships, for it being necessary, the school lacks the facilities as stated in paragraph 11 of the facts of the case. The school lacks the facilities to ensure the full realization of religious faith within the school. Such facilities include a place of worship, say a priest to conduct ceremonies, because in Article 21, Clause 1c, it gives people...
Can anybody quantify human rights in terms of finances, in terms of facilities? As you're calling subject, is it not a convenient argument?
Convenience, my lord, is part of public interest. So if the school cannot provide those facilities, that means it cannot accommodate it. And once it's unable to accommodate it and you are forcing it to bring about facilities that it does not have, it's going to stretch the facilities of the school and it's going to make it difficult.
But the objective of these rules and regulations override the constitutional rights. How so necessary is this objective such that we should allow it to override constitutional rights?
The Constitution in Article 23 gives administrative bodies the rights to set up their own governing rules in fairness and in reason. Hence, basing my argument on whether it is necessary and whether it is proportional. For the necessity, as stated, the school lacks the facilities to ensure the full realization of the religious faith. My lords, in the full realization of religion, as stated in Article 21, Clause 1c, the school would have to cater for its students in providing facilities for religion, such as a place of worship, as stated earlier. The school's resources, however, are unable to cater for this, meaning that it has to do so, meaning that if it has to do so, there will be a shortage of facilities.
Just 1 minute to round up. We have two questions, so we just have 1 minute to round up.
Most grateful, my lord. Such as classrooms, if we are going to convert classrooms to places of worship, it's going to limit the number of classrooms that are there for teaching and learning, which is directly going to affect the educational attainment of the students in the school. As for proportionality, the disadvantage once again is that the students will not be fully given the chance to fully realize their religious rights as stated in the Constitution. However, the advantages, is that it ensures that the facilities of the school are not overly stretched, and it places emphasis on the principal goal of education and ensures that students adhere to it, hence it being proportional, because this obviously shows that the advantage overrides the disadvantage.
Thank you very much. Thank you.
Thank you. My lords, I would like to invite my co-counsel to address issue 3.
Your Lordships, good morning. If it pleases the court, I am Golda, Selikem, Loisa, Amegashie, co-counsel for the respondent in the matter before your honorable court. I shall be addressing the third issue and I will be using a maximum of 8 minutes. If the court permits, I shall proceed with my substantive argument. The third issue for consideration by this court is whether the different classifications of uniforms was discriminatory, and this shall be answered in the negative. Counsels for the respondents believe that the different uniform classifications for the second and third year girls was not discriminatory, but for the good of all the learners and the people for whom it was prescribed. Per the definition of discrimination in Article 17, one may initially think that MFA and the other girls were discriminated against. But since this is a public second cycle institution, the prescription of uniforms is to ensure discipline. If the applicant is arguing under gender discrimination, then this cannot be valid. Per the facts of the matter, only the second and third year girls were to wear black and white attires. The first years cannot all possibly be boys, and the argument of gender discrimination is without merit. Your Lordships, the question that should be asked is, why is the dress code a problem if the school is achieving the excellence?
Yes, your co-counsel, a while ago submitted to us, relying on the authority of Nati and Gas, that equals must be treated equal. Right?
Yes.
So what is the difference between first year girls and second and third year girls? Why are they not treated equal?
Thank you, my Lord, for this question. According to this same case law, T.T. Nati versus Godwin Gatti, the court puts it crystal clear, please permit me to read, that Article 17 Clause 1 is not to be construed in isolation. Article 17 Clause 2 makes it clear that not all discrimination is unlawful. It prescribes discrimination based on certain grounds, and these are the grounds that I am about to expound on, my Lord. The question once again is, why is the dress code a problem now if the school is achieving the excellence? My Lords, please turn to paragraph 1 of the hypothetical facts. It states that Opimpim Senior High School was adjudged the best senior high school by the Association of West African Schools, and the main hallmark of the school is discipline. It also shows that in the past 15 years, it has been consistent with being the best school. Your Lordships, the argument is that how are the different classifications of uniforms affecting the girls, since, according to the facts, it shows that the school has been achieving its excellence based on the rules that have been set by the school. In Tinker versus Des Moines Independent School District, please permit me to read that portion. It says that schools may limit student expressions, such as enforcing dress codes, if there is a legitimate concern that such expressions will be disruptive to the learning environment or violates the rights of others. My Lords, yes, please. Please, it is an American. Please, it is 393 US 503 1969. Please, may I proceed? Thank you, my Lords. There is a need for the school to ensure that its core mandate of providing education is fully delivered and any trivial issue relegated to the background. Please permit me to make reference to expert knowledge. According to a study by Marks and Spencer, which is a universally recognized fashion label, it shows that females spend more time getting dressed, which includes the selection of attires. This, my Lord, is to show that since the second and third year girls are nearing their final exams, their syllabus is becoming more complex and they require more time to focus on their books, and this is why the school prescribed uniforms for them.
Is it a case that the first year girls can then just have fun before they get to second and third year?
No, my Lord, that is not what we are trying to do.
And once you get on your last case?
No, my Lord, please, that is not what we are trying to do.
Okay.
Therefore, the counsels for the respondents vehemently remark that the different classifications of uniforms for the second and third year girls is not unlawful as the applicants want to claim it, but are within the legal powers of OPMPM. They are not harmfully discriminatory, but are intended to be beneficial to the education of the girls for whom they are prescribed for. Your Lordships, please permit me to end my argument with a quote, and it says, "Successful institutions are not those that engage in knee-jerk decisions, but are those that envisage a situation and adequately plan and prepare for them." OPMPM's success is as a result of its diligence in foreseeing circumstances and dealing with them. Your Lordships, counsels for the respondents pray that this court is to make a declaration and affirm that the school reserves the right to prescribe uniforms for the use by its students, and that the regulation is not unlawful but constitutional. In summary, counsels for the respondents believe that these rules are to ensure the equal application of the laws for all and ensure fairness for the general good. Also, it is important to not open the floodgates for the assertion of rights which are not associated with the focus of the school. Finally, we believe that the rules of the school are meant for the protection of all learners, especially the females. All these rules collectively helped in the effective management of the school. It is the humble plea of the respondents that this court is to make a declaration to the effect that A. The refusal of the school to admit Kofi Painto because of his hairstyle is lawful and he should comply with it in order to be accepted into the school. B. The banning of religious activities is lawful so as to use the facilities of the school to the fullest educational benefit of all the learners. And C. The uniform prescriptions for the second and third year girls are lawful and for their own protection. Thank you very much, my lords. Yes, please. Thank you very much, my lords. Thank you very much, my lords.
The Amicus Curiae.
Respectfully, Your Lordship, I'm in Kattah, along with my co-counsel and other colleague, Agyapong, and together we represent the Amicus Curiae. Your Lordship, with your kind permission, I would use 12 minutes to address the first and second issue before the court, that is whether or not the failure to admit Kofi Painto was in breach of his human rights, and whether or not the ban on religion was in breach of the human rights of the student. And my learned colleague will address the third issue before the court. With your kind permission, I'll proceed into the facts of this case.
Sorry, Mr. Kattah.
Yes, please. Your Lordship, what we have before the court today is a clear violation of human rights by the respondents, which is OPMPM Senior High School. Your Lordships, Kofi Painto is a boy that did the best he could to be the best he can be in the world of academia. He attained the best results anyone can get in the basic education certificate examination and was shortlisted overall best student by the Ministry of Education. Your Lordship, he met the basic requirement for admission into OPMPM Senior High School, but the school denied him his right to access secondary school education in accordance to Article 25 of the Constitution on the basis of a manifestation of his religious practice, which is keeping dreadlocks. And would like to state that it is noteworthy that his dreadlocks is not merely a hairstyle, but a manifestation of his religious rights. Your Lordships, this same school in question, in a related development, according to paragraph 11, placed a ban on all religious activity, and their justification is that the proliferation of many religions is unsustainable, as the school cannot provide adequate facilities for all religions to effectively express their religious freedoms. Your Lordship, it is the humble submission of the Amicus Curiae that the refusal to, with your kind permission, I'll proceed to issue 1. It is the submission of the Amicus Curiae that the refusal to admit Kofi Pentile into the school was indeed in breach of his human rights. And we make this submission on 2 grounds. That he has the right to access secondary school education in accordance to Article 25 and Article 28(4) in the 1992 Constitution. And he has the right to practice and manifest his religion in accordance to Article 21, Article 12, Article 17, Article 26(2), Article 21(c), and Article 21(4)(e). Your Lordships, what we have before the court today is a challenge, as the respondents have placed before the court, where the right to manifest religion is coming in contrast with the right to education. And Your Lordship, it is the submission of the Amicus Curiae that none of these rights should supersede each other, and the actions of Opimpim Senior High School must indeed be in compliance with the 1992 Constitution, with the aim of promoting, not restricting, but promoting the rights of the human rights of the students thereof. Your Lordships, permit me to refer to the Taram Magua versus the Attorney General and Achimota School case. Permit me to read its citation. Suit number HR 0055-2021. Your Lordship, it was established in this case that the aim of schools is to achieve quality education and academic excellence. Your Lordship, it was also established that what compelling danger has a young man in manifesting his religion, that is in keeping his dreadlocks, posed to the students they enroll and posed to the quality of education they offer and academic excellence they seek to achieve. Your Lordship, it is the case of the Amicus Curiae that the dreadlocks of Kofi Pentile do not pose any compelling danger to the quality of education they offer and to the achievement of academic excellence. Your Lordship, permit me to refer to the case of Kwasi versus the Attorney General, the Office of the Civil Service, the Office of the Head of Local Government Service and Ministries, writ number J1 16-2106, 14th June 2017. It was established that, and it is the concession of the Amicus Curiae, that human rights are not entirely absolute, but they are subject to limitations in accordance to Article 12 of the 1992 Constitution. Your Lordships, therefore, there is a metric to be considered by all parties when limitations are going to be placed on the human rights of an individual. And this metric is that the limitation must be necessary and the limitation must be proportional. Your Lordship, it is the submission of the Amicus Curiae that the action of the school was neither necessary nor proportional. Your Lordship, it is the case of the respondent that discipline...
They say it's necessary because it's responsible.
Your Lordship, thank you for that question. The response of the Amicus Curiae. The respondents place a case that discipline and academic excellence have a relationship, and to achieve academic excellence, one must have a certain level of discipline. Your Lordship, I would like to refer to paragraph 1 of the hypothetical case. Paragraph 2, Your Lordship, pardon me. Where it is clearly stated that Kofi Pentile achieved the best anyone could achieve in the basic education certificate examination. That is then to imply that Kofi Pentile has a level of discipline that has helped him achieve that sort of academic excellence. And so for the past 16 years that he has been keeping his dreadlocks, it has not posed any danger to his academic excellence. Therefore, this is the submission of the Amicus Curiae that the school has no necessary grounds in restricting him from entering into their school. Lordship, on the case whether this action of the school was proportional, we believe it is not. Your Lordship, if you permit me to refer to the case of JWM Altas P versus the Board of Management High Schools and 2 others, 2019 EKLR. Your Lordships, in this case, it was established.
It's a Kenyan decision, right?
Yes, please, Your Lordship.
Okay. Right.
It was established that where genuine held religious beliefs come in contrast with school rules. The school and the individual must reach a compromise. Your Lordship, the school was not willing to reach a compromise with the students. It is the case of the respondent that Opimpim Senior High School has achieved all they can achieve in the past 15 years because of the rules and regulations that they have. And one student is not the need to bend these rules because these rules have proven a good roadmap for them to reach academic excellence. Your Lordship, we live in a changing and evolving world. And for a changing and evolving world, and hence Opimpim Senior High School has that mandate of constantly reviewing what they consider to be rules and regulations. But these reviews, however, should be considered in the light of if they help improve the quality of education and achieve academic excellence, or if they have no effect at all.
You think Opimpim Secondary School is living in the past, right? You want it to be modern?
Your Lordship, thank you for that question. We believe the actions of Opimpim Senior High School do not, the actions of Opimpim...
It's not the same with modernity, that's what you're saying. The board has said
it's... Thank you.
Basically, the school should take the times. Basically, the school should change for the times.
It is the submission of the Amicus Curiae that the rules and regulations of the school should be constantly reviewed for the benefit of the students, i.e. to achieve the quality of education, enhance it, or achieve academic excellence. Your Lordship.
When you quoted the Kenyan principles, in such circumstances, the parties must be the compromise. What would you see in your final submission? What would you see in the compromise? I would be interested to hear your take on the compromise.
Thank you, Your Ladyship. The compromise, the school.
Will you finish your, finish your submission?
Your Lordship, Your Ladyship, thank you. Amicus Curiae do accept that the Opimpim Senior High School, as per the Constitution, are mandated to set certain rules and regulations to enhance the management of the school. But Your Lordship, it is the submission of the Amicus Curiae that Opimpim Senior High School are not sovereign. They are not excluded from the state of Asawa. This school is subject to the 1992 Constitution, and every action they take must be in compliance with the 1992 Constitution. So on the metric of whether this limitation was necessary or proportional, the Opimpim Senior High School have not been able to prove that this metric that they have met this metric, and we as Amicus Curiae have shown you that they were not able to meet this metric, and hence their actions were unconstitutional and in breach of its human rights. It is the submission of the Amicus Curiae that the compromise of the school was to review their rules in relationship to the 1992 Constitution and accept Kofi Pinto on the basis of his merit and not the manifestation of his religion. With your kind permission, if there are no further questions, I'll move on to issue 2.
That sounds more like a very
Your Ladyship, as I have stated, thank you for that question, but as I have stated, Opimpim Senior High School are not sovereign, and so every action they take must be done in accordance with the 1992 Constitution. And with the metric we have presented, as you have indeed indicated, the school has to comply with the 1992 Constitution and permit him to enter into the school. Your Ladyship. With your kind permission, I move on to issue 2. Whether or not the ban on religion was in breach of the human rights of the students. Your Lordship, if you permit me to refer to paragraph 11 of the hypothetical case. With your kind permission, I would like to read. In a related development, all religious activity in the school was to be banned, and any student found engaging in same was to be dismissed immediately. The school's justification for same was that the proliferation of different religions meant it was not sustainable for the school to provide adequate facilities for all to exercise their religious freedoms effectively. Your Lordship, the actions of the school was a blanket ban, and hence, even students who were engaging in private worship were also affected by this ban, and hence their religious freedom the manifestation of the religious freedoms was totally curtailed. Your Lordship, again, the school has the power to set in place certain rules and regulations, but they have to come again in compliance with the 1992 Constitution and must face the metric of whether it was necessary or proportional. In the case of necessity, we see that the action fails because it was a blanket ban, and even private worship altogether was put aside. Your Lordship, we do sympathize with the school, with their claim. We do sympathize with the school with their claim that they are not able to provide enough facilities. But Your Lordship, it is the submission of the Amicus Curiae that the onus on the school is not to provide facilities, but opportunities for these students. We are not asking the school to give them tools for worship, but space to worship, and whether congregationally or in private. And proportionally, we do not, and in the case of proportionality, we do not believe, in the case of proportionality, the school falls short again. Because, permit me to use this analogy. Consider that some students in the school may not be comfortable with eating bean stew that is served in the dining hall of Opimpim Senior High School. Your Lordship, we find it very illogical or not proportional for the school to place a ban on serving food or preventing all students from eating food in the dining hall because a few students may not be comfortable with eating bean stew. Your Lordship, therefore, we believe, on the case of proportionality, it is the submission of the Amicus Curiae that the action to ban religious activity was in breach of the human rights of the school.
Wouldn't it rather be the school stop serving bean stew for all, just because a few don't bean stew instead of food?
Your Lordship, yes indeed, that would be the situation. But, again, as we pointed out, the school did not stop congregational worship, as implied by my analogy, serving bean stew, but put a blanket ban altogether. Even private worship was limited in their school, and hence their actions is similar to my analogy, where all food was banned in the dining room. Thank you, Lordship. My learned colleague will address the third issue.
Article 17. 2. A person shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or social or economic status. It is the position of the Amicus Curiae that when we take a look at the facts that were presented to us in paragraph 12 of the hypothetical facts, please permit me to read from that as well. Paragraph 12. In the highlighted section, all females in year 2 and year 3 who attend classes in black and white, all other students are at liberty to decide what to wear. All kinds and colors of attire are allowed. We see the very first impact when we talk about an intra-class division or an intra-class discrimination, where girls in a particular section have been given a particular limitation and girls in a different section have not been given that limitation. We see this to be in direct contravention to Article 17, where social discrimination or social status discrimination is prescribed as unlawful discrimination because individuals or females in higher levels or in Form 2 and Form 3 have been given a different treatment or a limitation to females in year 1. We see an intergender discrimination where no males whatsoever in Form 2 or Form 3 have been given this limitation. And this is what brings us to our next point, that the Amicus Curiae submits that even in the instance where this is such a benefit, as per the position of the respondent, this is such a benefit and an advantage to prevent distractions and to promote discipline. We say that in the case where it is such a benefit, we still see that discrimination. Why? Because boys are not being given that same benefit to ensure them to be concentrated or to prevent distractions in class or to prevent distractions in their academic work. Now,
you heard Ms. Amegashie submit to us that research, she relied actually on research. The research has shown that females spend more time in their dressing, and that's why men's dress code is able to demonstrate them. She also indicated that 2nd to 10 years, their syllabus is now very heavy, and that they need to make room for them to study.
Respectfully, Your Lordship.
So that's the reason why you have boys, but that's the reason why I feel it's right. Boys are keeping dress code.
Respectfully, Your Lordship. Thank you for that question. The essence of this limitation, if it is to prevent distractions, we say that in as much as girls might spend more time dressing up, boys and girls would spend time dressing up. So if in essence we are to limit the dressing time of students in order to ensure, to prevent distractions, then let's make it across the board to promote open secondary schools academic excellence, because there is nothing wrong in ensuring prevention of distractions across the board. And secondly, where they come to us, sorry for that. And secondly, where they come to us on where the distractions will be disturbing the girls more than the boys or anything like that, we say that in essence is an assumption, and that assumption is not acceptable because it wasn't given to us by the facts of the case. Now, Your Lordships, there is something that the Amicus would like to bring to the attention of everyone. Permit me to go back to paragraph 12 of the hypothetical fact, the highlighted parts. All females in year 2 and year 3 will attend classes in black and white. Please, the Amicus Curiae brings to your notice that the school does not dictate to them the type of attire to wear. The school is simply dictating to them the color of the attire to wear. So the idea we are bringing to you right now is that Pimpim Secondary School does not care the attire students are wearing, the attire Form 2s and Form 3s are wearing. They don't care whether these attires are promiscuous, are offensive, are indecent. They simply care about the color. So the question or the idea of discipline that we see on the side of the respondent is not legitimate. This is due to the fact that in any case, the student can wear anything indecent or exposing with a black and white color, and that in itself is still going to be offensive or indisciplined. And that's the position of the Amicus. And on a second level, we submit to you that the ending part of this paragraph, which says all kinds and colors of attire are allowed for all other students in the school, defeats the very purpose of discipline if we are to go with the assumption that this particular stipulation is going to promote discipline. This is due to the fact that if in any case, Form 1s or juniors who just came into the school and are to be bred by the school system are being allowed to wear whatever it is they deem fit, and boys from Form 1 till they leave the school are allowed to wear whatever they deem fit, then we say that the very idea where you are going to be getting discipline from the few girls in Form 2 and Form 3 is going to be trumped by the majority or the many boys who have been allowed to wear whatever it is they wear. It is the submission of the Amicus that Openpim Secondary School does not care about discipline. They simply care about limiting the expression of girls in Form 2 and Form 3. And the idea of discipline is just a front for them to perpetuate this indiscipline or this discriminatory beautifully. In essence, Your Lordships, the Amicus has been able to prove to all of us here that, first of all, not admitting Kofi Paintil on the account of his dreads was in direct affront to his human rights, and that the banning of all forms of religion in the school was also unacceptable.
Mr. Agyapong,
Your Lordship.
it doesn't lie with you to establish a unit in life that has made them determination.
Respectfully, Your Lordship.
Thank you.
I apologize for that. In summary, the amicus begs that Your Lordships would adjudge and declare that indeed not admitting Kofi Pencil into Opimpim Secondary School on account of his dreads was indeed discriminatory, and that was in affront to his human rights, and that the different classification of attire by the school was indeed discriminatory, and that the ban on religion was in breach of the human rights of the students of Opimpim Secondary School. Respectfully, Your Lordships, in the absence of any questions, I shall request you to be against it.